everyone. Today is September 19th, 2024, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan. Every Thursday morning, Jean Lawler and I are delighted to host another cutting-edge webinar for mediators, arbitrators, lawyers, and everybody who negotiates. There's no charge for these great webinars. Rather, we ask you to contribute to a food bank if you like what you see. And one of my favorite parts of the webinar every week is when we announce the running total of just how much our audiences have contributed since we began this series in 2020. Jean Lawler, would you please do the honors?
Well, and it's so great to see you all today. As of September 19th, 2024, so it's not quite a year and a half, we have been told of donations by people who have donated in honor of the speaker or just having attended these presentations, $616,406.52. That's well over 6 million meals served. And wow, what a difference we're all making in this world. So thank you so much.
Fantastic. Thank you, Jean. Thanks to all the people who have contributed and all of our great speakers. Today, we have another great presentation from Robin Cohen. Robin is the chair of the New York City law firm of Cohen, Ziffer, Frenchman, and McKenna, and she is one of the country's leading policyholder side insurance coverage lawyers. We're going to hear about insurance mediation, the policyholder perspective. Robin is the recipient of numerous awards by prominent organizations and recognized as one of the very best insurance coverage lawyers in the world. She's recovered more than 10 billion, that's billion with a B, in assets for her clients during her career over the past 30 years. Robin counsels an exclusive policyholder client base spanning industries and countries, astutely advocating for them in cases involving asbestos, directors and officers issues, employee coverage, employee dishonesty, environmental issues, first-party property cases, product liability, toxic tort, and other claims. Her excellent courtroom skills and trial success have brought her recognition as one of the National Journal's 50 most influential women lawyers in America, a recipient of the 2020 Legal 500 Advice to Policyholders Hall of Fame honor, and Benchmark Litigation's top 100 lawyers in America. As lead counsel in groundbreaking cases before many of the highest courts in the United States, she routinely negotiates settlements in the multi-$100 million range. Her dynamic trial presence, agile and quick-to-pivot thinking, excellent listening skills, and refreshingly direct and often humorous delivery gain the respect and admiration of judges, juries, and adverse lawyers alike. We're looking forward to just that, those listening skills, that refreshingly direct and often humorous delivery today as well, Robin. So please tell us a little bit about the food bank to which you would like people to contribute if they're able to do so. And then on with the presentation. Robin Cohen, the floor is yours.
Well, thank you very much for that introduction. It's a pleasure to be here, and I look forward to the conversation. It's great to meet everyone by Zoom. The charity is the World Central Kitchen. They have provided fresh meals in response to humanitarian, climate, and community crises. Probably one of the ones that I am most passionate about is the crisis in Ukraine. And that is one of their targeted audiences, and they've been very instrumental in providing food and meals there. So that would be the charity that I am focused on today.
Fabulous.
Okay.
And now, please, let's hear about policyholder perspective.
Okay. So I thought I would start with both everyone understanding that I've been representing policyholders exclusively for over 35 years. I'm always on the policyholder side. All of my disputes, whether they're in litigation or not, are against the insurance industry. And as was stated, most of our cases are pretty large cases, many of which start out at least trying to mediate. And I would say approximately half of them are successful during the mediation before litigation. And then probably another 25% while we're litigating, we use the leverage of the litigation to mediate. And then some after judgment or a trial, we then mediate. But I think mediation is a very, very important tool. From the policyholder's perspective, mediation with the insurance industry is very different than mediating between two large companies. And one way from the policyholder's perspective, it's very different, is that the insurance industry negotiates differently. They tend to be very patient, very tedious. They tend to lowball the policyholder for a very long period of time. And so as the policyholder counsel, it takes a lot of patience and calmness. Two of the qualities I wouldn't say are my best qualities. So, interestingly, now when the insurance industry mediates with me, I think they do a little more, they pivot a little bit more, and they try to get to the bottom line a little quicker. One reason a lot of mediations with the insurance industry are not successful in the beginning is because a lot of times the insurance policies require a mediation before you can bring a lawsuit. So if it's that you have to check off the box for the insurance industry, in those situations, and I think it's important to manage the client's expectations. In those situations, it doesn't matter who the mediator is and how strong your position is, it's likely to be unsuccessful. Now, in those situations, what I try to do often, and monumentally unsuccessful at it, which is to try to get the insurance carrier to waive a mediation, since it's really not going to be a productive exercise. Typically, they will refuse, and you're wondering why would they do that? The reason they will do that is because they're holding the money, and they want to use the obstacle of having to go through a mediation as a form of delay. Because in in our situation, delay is often denial. So the longer they can hold the cash, the more they, don't have to pay it out, the more they can invest it. So they use it as a delay tactic. But if we are assuming that we are in this space where the insurance industry is not required to mediate and they are there because they want to be there, then you're in a very different situation. And from the policyholder's perspective, and from my experience, when the carrier asks for mediation, that is probably the biggest indicator that you might be successful in your mediation, because that shows that there is at least some interest in mediating. It's very important in my world that you manage the expectations of the policyholders' clients in a very clear way, because often I'm dealing with large corporations or private equity firms or hedge funds who like to get to the bottom line very quickly. And as I said before, that is not how the insurance carriers negotiate. And if you try to get to the bottom line too quickly, all that will do is likely lead to an unsuccessful mediation. So you sort of have to do the dance. You have to negotiate a little bit on their playing field if you want to be successful. And I think it's important that you explain that to the client, because they're used to getting to the bottom line much quicker. The most or the largest indicator, in my view, of whether the mediation is going to be successful is if you choose the right mediator. I have given speeches on this a lot because I have been critical of a lot of mediators that I have used in the past. And probably the biggest criticism I have of mediators is that they don't strong arm both sides, and I'm including me in that conversation. What I mean by that is the mediators are typically very good at listening to both sides. They're good at explaining the weaknesses of your case and the carrier's case, but they really don't push both sides in a very strong way. And I don't mean screaming and pounding the table, but I mean in really pushing both sides. And the best indication is I don't feel in most of my mediations that I'm pushed significantly. And so what I have advised, and my success rate in mediations has gone up substantially, is I have started to pick mediators that are not only bright, understand the subject matter, but really will use the force of their personality to push both sides. And it's important to do that when you have the right people in the room, which is another problem. Often the carriers do not bring the right people in the room. They bring low-level claims handlers. And so at my age and my experience, I will not attend a mediation unless I know for sure that you've got very senior level folks that really have decision-making power to come to the mediation, be prepared to engage and to settle. The other thing that won't surprise you, but many of my mediations lead at the end of the day to a mediator's proposal. And that's when the mediator gets the sense that both sides are pretty serious about settling. And so often everybody, both sides forego the presentation in the beginning, which I think is typically a good thing because usually you know both sides. But I do believe what most litigants and most lawyers don't appreciate is you really got to get the mediator on your side on a substantive basis. Meaning you really have to demonstrate why your position is stronger, why you have the leverage, what sort of financial factors really will be in play, like prejudgment interest, which in my case, a lot of these cases are large. You don't have to prove bad faith. And prejudgment interest can be a very big factor in getting cases settled because nothing makes a claims handler get fired more in a situation where they have to pay over their limits of their policies. So it's really important that you really try to get the mediator on your side on a substantive basis. But the other thing that's really important is you also have to listen, as Jeff was saying, and you have to acknowledge the weaknesses of your position too. You don't want to appear to the mediator that you are completely out to lunch and you're just not listening and you just think every position you have is great, because it's not. And what I tell all clients, and it's no secret, you could have a slam dunk case and you still have a risk of losing like around 15 to 20%. I mean, I win cases all the time I should lose, and I lose cases sometimes I should win. And it's just the nature and the riskiness of litigation, and that's why mediations work. But if you go in telling your client you have 100% chance or 95% chance of winning, then the mediation's not going to be as successful. So getting back to the mediator, I think it's really important to pick someone who has the reputation of really pushing both sides. I also think it's important that you consider a mediator that the carriers want to propose and vice versa. Because I can tell you, if my client is really eager to settle, I will often go with a carrier's recommendation because the carriers are more likely to listen to that mediator. I won't pick a mediator who I think is too soft, though. And I'll make that pretty clear to the carriers. But the same thing is true the other way around. And I've made this point to the insurance industry because I have spoken in front of them on at a conference where you had very high level executives there. If you, as the insurance industry, really wants to settle, and I have the ear of the client, you would be much better off picking a mediator that I respect, because I'm much more likely to listen to that mediator as he or she identifies the weaknesses in our positions. I had a mediation recently. There were literally 20 carriers in one room. We barely could fit everybody with their counsel and everyone. But we picked a mediator that was, I think, is one of the best mediators, and he identified some weaknesses in our case that I really didn't think were weaknesses. But the more he spoke, the more I realized that there was some real merit to his discussion. And frankly, my client also realized it. And we have settled with 18 of the 20 carriers as a result of the dialogue with the mediator. So, again, it goes back to picking the right mediator, but also picking one that either both sides, respect, or if you really want to settle with the policyholder, picking one that, has the ear of the client, which is usually the counsel. The next question that I'm often asked is whether I prefer mediations in person or by Zoom. I will tell you, I am much more effective in court in person than I am on Zoom. I'm always worried about the technology and it's gonna fail. And I actually think that mediations work much better, especially ones that are complicated and involve a lot of parties, when you're in person. I feel the conversations outside of the conference room where you have relationships on the other side work much better if you are in person. And I personally have been more effective, and the success of the mediation is more likely if I'm in person. Some folks don't agree with me. I mean, we've done trials by Zoom during COVID. And we've done mediations by Zoom, but I think it really depends on who the parties are and who the counsel are. The older the counsel, I think they think the more effective it is in person. Another issue that comes up in my area is it's the policyholder, a large policyholder against 5, 10, 15, 20 insurance carriers. And the question is whether you mediate as a group or you try to pick them off one by one. And what I find is that if you mediate with the carriers as a group, you often get the lowest common denominator influencing the entire group on the carrier side. So I rarely will negotiate with carriers as a group. Sometimes I will have subgroups, but often I tend to do mediations with carriers one by one. Or if I do it as a group, I separate them because I don't like the group dynamic. It typically doesn't work well. Getting to the actual negotiation, I think one of the mistakes that folks make in my area is we get to, the ranges too early. I think that with the industry, you've got to do the dance back and forth. They'll lowball you, you lowball them. You have to go back and forth. And one of the reasons is that often the carriers have their coverage reinsured by other folks, other companies. And they are expecting the insurance industry to move very slowly. So in a situation where you have a three-way dispute where, let's say, investors have sued my company as a securities fraud case, and the carriers are there, and you're negotiating with the underlying plaintiff investors. The sophisticated investors and the sophisticated counsel, everyone knows if it's really carrier money, you got to move relatively slowly in the beginning. It's just how they roll, and you just have to deal with it. At a certain point, though, I do find ranges can be very effective. I think it gives the mediator a lot of information as to where parties really are. I've had a number of mediations in the last 5 years that went off the rails when the mediator communicated to the other side something they should not have communicated. And it's typically the counsel's fault, meaning the counsel doesn't, on either side, does not make clear that a certain fact or certain position should not be communicated to the other side. I recently had a case that was literally worth $1 billion that almost went off the rails in the mediation because the mediator communicated something to the underlying plaintiff that he should not have done. But I typically, usually when you're dealing with sophisticated mediators, it's usually the fault of the counsel. So that's one way that things will go off the rails. The other thing is, I think people underestimate the importance of relationships. So, it used to be that, I had a reputation of litigating and trial work and being very, very gung-ho on every case goes to trial. I think what I've done and some of my competitors have done is gotten to know folks on the other side. Not just the lawyers, but the senior folks at AIG and Chubb and a lot of other insurance companies. And I do believe that forming those relationships can make a big difference on the success of the mediation. I also believe that if the mediator has strong relationships with not just the counsel, but the in-house folks, that is also a very strong data point on whether the mediation will be successful. So I tend to choose mediators that have dealt with the insurance industry, have strong ties at the upper levels, but you gotta thread this needle. You don't want the mediator to have the reputation of being beholden to the insurance industry, which a number of good mediators do. And so what happens is these mediators just get blackballed in the sense that that policyholders counsel will not use them. So I think the message is, I think bottom line is pick the right mediator, know your audience on both sides. To give a little example of that, and which I'll end, and I'm happy to take questions. It's really important to understand who has the ear of the client and who is really making the decisions. And a good mediator really can figure that out relatively quickly. And some of the better mediators that I've worked with understand that if the carrier continues to lowball us, we'll walk out. Because I understand that there's a little bit of a dance, but at a certain point, both my personality and, my clients typically just have had enough. And so even though Jeff and others will tell you it's going to take a good 8 hours, it could be 9 or 10. If the first couple hours we feel like we're not getting anywhere, we will walk out. And I had an experience actually as late as Monday where both sides were really not moving. And the mediator, who has mediated with both me and the other side extensively, said, why don't you give me a range privately, and I will then give a mediator's proposal. And literally, the mediation ended successfully within an hour and a half by doing that. And that was because both sides respected the mediator. He understood that he probably needed to get to the bottom line quicker with me. And he understood that I would tell him honestly what our range is, because often counsel won't tell the mediator what the range is. And so it ended quickly. So I think relationships matter a lot, and I think the mediator is probably the most important part of the process. So I'll stop there and see if anybody has any questions or thoughts.
Well, Robin, thank you. There's so much there. Let me start with a few and then we'll invite others to participate as well. You made some provocative comments about mediators strong-arming both sides, including you. Now, your reputation is not exactly as a shrinking violet or somebody who is strong-armed easily, in the sense that you have a reputation as someone who comes to a mediation very well prepared, and you know your case. The mediator finds out about it a week or so in advance when we get the briefs. So let me ask you, don't protect the innocent by not including names, but why don't you tell us about a time when a mediator strong-armed you successfully?
Sure. So I just had a mediation where there was 20 carriers. And I felt pretty bullish on our position. The case, we filed a coverage litigation in Delaware. There were 20 carriers on the other side. Often, and it was coverage for a securities SEC case. And what I found interesting is the mediator strong-armed me in a specific way. He did it on a substantive, analytical basis. And he explained to me why he believed our position was incorrect from a securities perspective. You know, one of the things that mediators in the insurance space have to realize is we're insurance lawyers. We're looking at it from an insurance perspective. Typically these good mediators, while they have some insurance experience, they really, they're more general practitioners. So he looked at it more from the underlying securities law perspective. And the more he spoke about securities law in Delaware, and the more he spoke how that might impact the coverage issues, he really made an impact both on me and my client. So it was more engaging with me on a substantive level. I mean, I think that some mediators, they basically go back and forth on the numbers, and they don't understand that making sure or feeling comfortable the mediator understands the parties' positions and can engage on a substantive level is important. So I think that's the best example. And I will tell you, he did the same thing on the other side. Now, he was not effective in the mediation because there was 20 of them and he was getting the lowest common denominator. But after the mediation ended, I mean, I had 5 carriers call me almost immediately to settle. So it was him engaging with me on the substantive level on securities laws, and I think engaging on the other side on the weaknesses of the position.
So in that situation, talking about the merits and the substantive law and engaging substantively like that, I would distinguish that from classical strong arming, which is more settlement for settlement's sake, the kind of pleading, come on, you're so close, give me a little more money, we got to get this thing done here. You just have to for the sake of settlement. Do you draw that distinction in your own mind as well? And can you comment on the latter sort of tactic by mediators?
Well, one of the tactics that is very effective by mediators is if it's a directors and officers case and the D's and O's are implicated. sometimes the mediator will use scare tactics and really push hard how you might think you're right, but if you're wrong, the D's and O's could have a tremendous amount of exposure, and they could go overboard on identifying what that exposure is, really to scare the policyholder, counsel, and the directors and officers who are typically on the board of the company. And it can be effective, but you've got to thread that needle very carefully, because you could offend the D's and O's, and they could see it as an attempt to push too hard, especially if it's very transparent. So I've had situations where it's been effective, where they pushed very hard. But I've had situations where it backfired and the mediation just exploded, because the D's and O's didn't have a lot of respect for the mediator. So I do think former federal judges sometimes have, if they're mediators, sometimes have more gravitas in those sort of cases. But you don't have to be a former federal judge. But strong arming on the substance, but making the D's and O's feel that they're at risk is a way of strong arming the policyholder, and you have to do it carefully.
So it sounds like it's really engaging on the merits, on the substance of it, and not just settlement for settlement's sake. Is that a fair distinction to draw?
I do. I think so. I mean, look, one of the things that the mediators will talk about is the press. A lot of my cases are pretty high profile. I have one right now where some executives left a company, and it's a very nasty public dispute. I think the mediators use not just the substance or the merits of the litigation, but all the things around it, like the media, other, business relationships. But I think those are fair game. I think it's something that the mediator should be able to use. And I would call it part of the arsenal they have. I don't necessarily think that's strong arming, but it's certainly getting closer to, putting significant pressure on both sides, which I think is what you have to do. I will tell you, in my space, my view is the only thing the carriers understand is leverage. But leverage doesn't have to be just litigation leverage. It can be leverage in the media. It can be leverage in business relationships. It can be all sorts of different types of leverage. But I do think the only thing that works is if you have leverage.
So in terms of equipping mediators start out as the least knowledgeable person in the room about the dispute. You've been living with the case for months or years. Mediator brought in on relatively short notice. Let's talk about how you equip a mediator, how you prepare a mediator for a mediation. What do you recommend to other lawyers in terms of the preparation and equipping the mediator to do the job?
So I believe that the mediation statement is very important. And I also believe that it's important that it's transparent, meaning the other side gets it. I mean, I have had situations where we've given the other side our mediation statement, then we have a private, 3 or 4 page statement to the mediator. And I think that's a very effective way of getting the mediator prepared. I will tell you, the insurance carriers' mediation briefs are typically terrible. They just do not put in the time. And I think it actually helps the policyholder a lot, because I think the mediator walks in most of my cases, thinking we have the better of the position. And I really think it's mostly because they don't take the time to do a really careful mediation statement for exactly your reason, Jeff. And the mediator's coming in cold, and you have to get them up to speed. The other thing I am very much in favor, and I know, Jeff, you do it and others do it, is I think it's really important to talk to both sides before the mediation. I really believe you got to set the stage so the mediation starts off on a good note. And so I think those private conversations after the mediator has read the briefs is good. I will tell you a couple times I've had these calls where it was clear to me that the mediator had not read either brief, and that's a total waste of time. And I actually, in one case, told the mediator we should have another call after you have a better opportunity to look at the briefs. Did it much more nicely than I just said. But and we did it, and and it was a much more successful call, and frankly, a much more successful mediation.
So in submitting a mediation statement or mediation brief, you want to establish your credibility with the mediator, that you're well prepared, putting the client's interest ahead of your own and all the rest of it. At a more nitty-gritty level, what general rules do you have to impart to other lawyers about how to prepare an effective, good mediation brief or mediation statement?
So I am of the view, not only in a mediation statement, but in all advocacy pieces, your preliminary statement has to be the best. You have to grab the attention of the mediator because he typically has a lot of different cases. You've got to be pointed, and you've got to be blunt, and you've got to be clear in your statement, because that sets up the entire mediation brief. I do that with my the briefs all the time. I mean, I focus more on the preliminary statement than anything else. So I am of the view, if you wanna really get the attention of the mediator and get them on their side, that is the most important part of it. The other thing that I find effective is charts. Whether you put the charts in the brief or you put them as exhibits, I am very chart oriented. And I think these issues can get very complicated, especially the coverage issues. I think it's important to have the policy language in a chart. And I think that I have a chart on our position, the carrier's position, and why we're right, which is like a summary. Because I do find that, mediators get busy, and it's a pretty effective way for them to have a cheat sheet.
And then in the phone calls that you have with mediators, and I agree, those are critically important. How candid are you with mediators about relationships with your own clients?
I tend to be extremely transparent and blunt. I cannot tell you how many times I have gotten the comment back from the mediator, I appreciate your transparency, because a lot of people are not that way. I've been that way for a very long period of time, and it's been, I find, much more effective. I don't think it's great to game the mediator, especially if it's a mediator that you deal with a lot. Because one thing that can get a mediator's back up, as you know, Jeff, is if you are dishonest or you make a misrepresentation. We were just involved in a mediation where a carrier made a pretty significant misrepresentation before a mediator that a mediator that is one of the best. They could not recover after that. So, there's one thing not to, put all your cards on the table. It's another to make an affirmative misrepresentation. And so you got to be very careful. But I do believe the more blunt you are, the better. But you have to have the right mediator to be that blunt.
So let's zero in more on the nature of the relationship between you and your clients. You talked about strong arming. You talked about pressure. You talked about discussing things on the merits. And oftentimes, I think what we're doing as mediators is we're helping lawyers get unrealistic expectations down to planet Earth, get repair what might be rifts in attorney-client relationships, help good lawyers break bad news to their own clients. If that's the situation you face, and even the best lawyers face those kind of situations, talk about the teamwork between you and the mediator, how you set that up, what your expectations are of mediators in that regard, and that whole angle of things.
I make it pretty clear to the mediator that, I've got a very sophisticated client. They feel very strongly about their position. They can be very difficult, but they're very savvy. And I sort of arm the mediator with the best approach to a particular client. Some mediators, some clients, it's being more substantive. With other clients, it's being they want to understand what the mediator's belief is and the chances of success. And some mediators won't do that. Some of the folks that I report to, and I typically report to the CEO or the CFO or the GC, and sometimes all three. A lot of the folks that I represent are very financially oriented, and they really want to have, want to understand bottom line what their chances are from the mediator.
Mhm.
And when they get a lot of caveats and they get a lot of, hedging, it turns them off. So one of the things I arm the mediator with, I make it clear who you're dealing with, whether they're financial folks, they're bottom line folks, what will be effective, what won't be effective. I don't obviously breach the attorney-client privilege, but I do make it clear how you can be effective with my client. And I do think that's important because I do think with the level of sophistication with some of my clients, the right approach is important.
I'm glad you all mentioned cluing mediators in as to what has been tested and disproven and what not to try with a client, because that at least gives the mediator a fighting chance to do something that actually will work if we know not to get the false starts. Let's talk a little bit about caucusing and the confidentiality. You said that counsel sometimes doesn't make clear what can and cannot be communicated, and that mediators sometimes leak, I think is the technical term that a lot of mediators use. And mediators, even when we don't intend to, can sometimes leak through facial expressions, tone of voice, body language, and things like that. When do you like to keep more control over that sort of thing by having direct communications and talking directly with counsel for the insurance carriers or other principals in the mediation, so that you have control over what actually gets communicated and how, as opposed to when you rely on mediators to do that, understanding that mediators may leak?
The mediators that I use, I'm very comfortable they don't leak. The one that I just was involved in where it was a leak, it was someone that I had not used significantly. I was brought in late in the day. The mediator was chosen before I was involved. So with the mediators that I'm comfortable with, I let the mediator do their job. And typically when I have direct conversations with the client or the counsel for the carrier or the carrier, it's when the mediator is blocked, meaning they can't go any further. And I know that it's not going to be a successful mediation if we stop at this point. So what I will do is I will typically, especially if I have a good relationship with the counsel for the carrier on the other side, I will go into a private room, not embarrass her or him in front of her own client, but we'll have a private conversation about how we can bridge the gap. Everything's off the record. Nothing can be used against each other. And I will tell you that in the last few mediations that I've had where there were a lot of parties, that has been a very effective approach. And in fact, in one of them, the mediator said to me, the counsel for the carrier wants to talk to you privately. And, one thing that I believe my firm has a reputation of, and this firm on the other side does too, is both sides tend to be very creative. And so We came up with a creative solution. We talked to the mediator afterwards, whether he thought it would work, and it did work. So, again, you have to have some credibility with the other side. And at this point, I know everybody, like, and they know me. So it's like, it's like some people I don't like and some people I don't trust, but there is a good portion of the carrier industry, which I do trust when they say they're going to do something, they do it. And they do it, some of them do it because it's a smart way to be, and they want to be able to deal with me in the future. So, it works, but I do think I usually do it when the mediator's blocked and can't go any further.
What does that mean, the mediator is blocked?
What it means is that we're too far apart and neither side is moving. And so the question is how best to get there. I mean, typically mediators don't want to give mediators proposals unless they think both sides are going to accept it.
Right.
I have never been in a situation in the last 5 years where a mediator gave a proposal that wasn't accepted. So what the mediator will say is you guys are too far apart and I can't move either one of you. And that's when I start engaging directly with the carrier.
That, in a sense, encapsulates what good mediation many times is, which is creating the environment and the circumstances where the lawyers and your own clients can do the best work of which you're capable and get those deals done.
And I will
yes.
say, Jeff, on that note, I find it's much more effective if you have that, block, whether it's to go personally in a room with the carrier's counsel and try to resolve it. I do think that personal touch can make a difference. Now, you could do it over the phone. It just doesn't have the same impact. The other thing that I've used effectively is if I like the broker who's brokered the account, and there's some brokers I think are very effective and others ineffective. If I think they're effective, often they can go above the person that's there at the mediation and call very senior level person at the carrier. So that's another way I break the ice. If there's an impasse, I will use the broker to play sort of the good cop, bad cop scenario. I'm the bad cop, by the way.
And is that something you do in the moment? Do you tip the broker off in advance? Hey, I may be calling you. Do you have the broker show up at the mediation? Do you just call them out of the blue? How does that go down?
So depends on the broker and depends on the case. But my last 3 large mediations, I had the broker with me. And it was very, very effective because that broker can make calls to the carrier directly, which I cannot do. Obviously, I have to go through the counsel. It can create a very good dynamic, especially if you're at an impasse.
And especially if the broker places a lot of business with the carrier, right?
Which the ones that I'm talking with all do.
Right. So the so-called commercial accommodation settlement. Do you see a difference between United States and London brokers in terms of their participation or effectiveness in that regard?
Yes, it depends on who it is. I find some London brokers very, very effective. I will tell you, though, negotiating with the London market is probably the most frustrating out of all of the carriers, only because they are incredibly, I am overstating this, but they are incredibly patient. They are incredibly diligent and they move very slowly. It can be very effective, but I do find that mediations are not going to go quickly if you're dealing with the London market. Which brings me to another point. I often will only agree to a 3 to 4 hour mediation. I'll start at 1 o'clock and say, we're not doing the whole day, because I typically find the first couple hours a waste of time anyway. I will tell you, for some of the more complicated cases, all that means is you're there till 12 o'clock at night. So it's not necessarily better. I've tried that to try to streamline it and make it quicker, but I'm not sure it's effective in doing that.
Well, if you have 10 or 15 or 20 carriers, 4 hours requires people to work very fast.
Yeah, and the London folks are, on London time, so they're gonna. It's they're not so happy about going till 12 o'clock at night.
And I must say that your description of the carrier's negotiating style as patient is one of the all-time great reframings. And
Yeah,
agree.
they are definitely. I mean, one thing to be, one thing that I think is important, and I stress it with my clients, but sometimes they don't believe it, which is, when they lowball you for a while, it's just that's what they're taught. And that doesn't have any indication where they're going to end. It's very hard for corporate America to understand that. Because they negotiate, these general counsels and CFOs negotiate all the time, and they typically don't get lowballed for a long period of time. So it can be incredibly frustrating and create a bad dynamic.
And there are ways to deal with it. We have a few minutes left. Jean, I want to give you an opportunity. First, you're such a veteran of the insurance industry, having represented carriers in big ticket disputes for so many years before you became a mediator. Thoughts, questions, please?
Wow, I loved hearing what you said, and I love listening to the vocabulary. It's like leading parallel lives in the vocabulary alone. This is great. One thing that struck me, I made a note of, is you talked about mediators being beholden to the insurance industry. Are you talking about mediators who are still working on the defense side, so that they're actually advocates as well? Or do you think that individual mediators that all they do is mediate or arbitrate are beholden in some way to the insurance industry?
I'm not talking folks that actually work for the insurance industry, but
Yeah.
they have the reputation of being beholden because they get a lot of repeat business.
Mhm.
And so there are certain mediators that we will not use because we don't think get into the merits. They seem to always side with the carrier's position, no matter how meritless it is. And it could be an unfair view, but policyholders counsel speak all the time. And I'm
Yes.
always asking, I'm always looking for new mediators, by the way. I'm always looking for new mediators because I don't think you have to be experienced in the coverage area to be an effective mediator for us. And the reason I'm looking for them is, and the same thing with arbitrators, is look, the insurance industry is as you know, a very powerful industry. And they have a lot of repeat business. And my client is probably going to be one off or maybe two off. Maybe they'll have a couple cases for them. But AIG will have a lot of cases every year. And so the mediator has to be careful because you'll see that some of these mediators won't get picked at all because the policyholder council will just block them.
Sure, that makes sense. Another thing, you used a word that I use all the time when I'm in mediations, is ranges. And lots of times the participants will talk about brackets, and I go, oh, but brackets. And I actually use the phrase, who in America likes to be told what to do? Nobody. So don't say, you go to this, we'll go to that, in the traditional sense. So you find the use of ranges as such to be much more productive, right? It sounds like.
I do. Now, the mediator can guide us. I will ask, like, I'll make a counter and I will say to the mediator, do you think this is productive? And often they'll say no. They'll say, I think you need to give a bracket. But I will tell you, Jean, we had a situation where I gave a bracket recently and the other side didn't understand what a bracket was. And it took a lot to figure out the whole bracket thing. So it could be confusing to unsophisticated person on the other side. I will tell you that with respect to brackets, if the bracket overlaps, it's more likely you are going to settle.
Yes, clearly, because you've got an area.
You've got an area.
Which you'll agree, yeah. The dance
Yeah.
floor has narrowed, yes.
Yeah. And to your point, sometimes the other side, they do not want to be told what to do. Like if I sit back and I say, look, we're not countering. This is ridiculous. And the mediator will say to me, I don't think that's the right approach with this particular client, meaning the carrier. And I do think you have to listen. You don't have to listen all the time, but you have to try it on. And there has to be a certain amount of trust with the mediator, which brings me back to my main point. I won't mediate anymore unless I have a strong amount of respect for the mediator. I just tell them I'm not going to do it. I'm not going to waste my time. I will say this too, because I know we have a lot of mediators on the phone. It can be counterproductive to mediate, because what happens if my client is so frustrated by the mediation, they're going to tell me to go forward with the litigation and they don't want to have any further discussion with the carrier. And some clients really mean it. And so a mediation can actually backfire and create more or less of an ability to settle as the litigation goes forward.
Well, excuse me, let me ask, we only have a minute left. Let me ask you about those backfire mediations. One of the very first things that you mentioned were contract provisions and insurance policies that require a mediation. There's also courts who will require you to mediate based on the court's interests or the court schedule rather than perhaps yours. Do you find the backfire mediations take place more often when the mediations are compelled rather than voluntary?
No, in fact, the reverse.
Really?
Because with the required mediations, I tell my client it's going to be a waste of time. So they are already prepared that this is not going to work. Where they really get their backup is when the carrier has requested the mediation. And then they come and they don't bring the right person, or they act in bad faith, or they don't really meaningfully negotiate. And that is when the client says, screw it, we're litigating. I don't want to hear from these folks again. That's when it really backfires.
Got it. Well, we could carry this conversation on for a long time, Robin, and I want to unfortunately tell you we're out of time. It's been a fabulous conversation, very illuminating and educational for me, and I hope for everybody else who's listening both here and who will be listening to the recording when we post it online. I know that I'll be contributing to the World Central Kitchen in your honor, and I'm confident that many others online here viewing this will be contributing to the World Central Kitchen in your honor as well. And Natalie has posted the link to the World Central Kitchen in the chat. We hope that people take advantage of that. Thank you so much, Robin Cohen. On behalf of Natalie and Jean and myself, we appreciate this greatly. We thank you. And with that, we are complete.